All rise. Ladies and gentlemen, the Supreme Court of Alabama. Hear ye, hear ye. The Supreme Court of Alabama is now in session. God save the state of Alabama and bless these United States and bless this honorable court.
Please be seated. One administrative matter before we get started. Justice Bryan was not here for the first case or this case, but he will participate by watching the DVD of the oral arguments. And so with that, Madam Clerk. Oh, yes, and we do have Justice Cook recused because his former law firm is involved. It's only for this second case. Madam Clerk.
Case number SC 2023-0516, City of Helena v. Pelham Board of Education, Rick Rhoades, Angie Hester, Bob O'Neill, Robert Plummer, Sharon Samuel, Scott Coefield, and Chuck Ledbetter. Arguing for the appellant, the Honorable Ed Haddon, and arguing for the appellee, the Honorable Carl Johnson.
Let me just clarify for the clerks that are here, the interns, that we have a prohibition in our rules of evidence for, rules of ethics for a judge participating in a case involving a law firm that he's recently left. And so that's why we have Justice Cook not participating as a sitting justice in this case. So, Mr. Haddon, if you would, please.
Mr. Chief Justice, and may it please the court. The question in this case is whether the City of Pelham's Board of Education can operate a high school practice field, not in the City of Pelham, but across city lines in the City of Helena, in that red patch right there. You see, Pelham is in blue and Helena is in tan. The answer to the question is no for three reasons. First, the jurisdiction or power of a governmental entity is limited to its territory where its voters reside, vote, and pay taxes. Second, the Alabama legislature that wrote the statutes for city boards of education provided that city boards of education have to operate within their sponsoring city and in any adjacent territory that is annexed into that sponsoring city. And third, the practice of city boards of education in Alabama is to operate within their city limits, or if there's property outside, to go and annex it in. And that happened in this case between these parties. In 2015, the city of Pelham came to Helena and said, we'd like to use some property for a girls' softball field. It's in Helena. Will you de-annex it into Shelby County so we can annex it into Pelham? And we did, and they use it today. Then in 2018, they came to us for that 52 acres in red right there, and they said, will you de-annex this 52 acres? We'd like to use it as a practice field. And we said, well, tell you what, we'll do a land swap with you. You give us 52 acres, we'll give you 52 acres. We don't hear from them for 3 years. And the next thing you know, the bulldozers are running, and they're just running over us. No annexation, no agreement, just building it and running over us, and that's what precipitated this lawsuit. Now, with respect to the government having its power limited by its territory, in the Declaration of Independence, after listing our inalienable rights, it says, to secure these rights, governments are instituted among men, deriving their just powers from the consent of the governed. And that's why we look at our First Amendment to the Constitution that gives us freedom of speech and freedom to exercise religion. And it doesn't have a clause in it that limits the geographic scope of that amendment. But no one would argue that it applies in Calcutta, India, because the people in India didn't ratify the Constitution, and they have no recourse there. Similarly, the statutes of the legislature of California, even if they don't have a geographic limitation, they don't apply in Alabama because we didn't elect the legislators in California, And if they do something we don't like, there's nothing we could do in Alabama. So they don't apply here. And the same thing goes with Helena. The people in Helena don't get a vote in the Pelham City elections, and they don't pay taxes to Pelham. If governmental power is affected inside Helena, they have no political recourse. And again, when the statutes were passed, they adopted the same principle. They said, we're going to make education local. There's not a central Bureau of Education in Montgomery that makes all decisions for boards of education around the state. Instead, it's the local city boards of education and county boards of education. So the mamas and daddies, whether it's in Montgomery, Pike Road, or Dothan, Alabama, the mamas and daddies that live there get to make the decision about who's going to sit on the city council. They then appoint who's going to be on the boards of education and what taxes they're going to pay. So they have control over their own children's education. Okay? Now, back to the practice. In 2022, this is on page 30 through 33 of our opening brief. In 2022, the Homewood Board of Education wanted to use a parking lot, but it wasn't in the city of Homewood. And so the Homewood city goes and annexes that into the city of Homewood and gives it to the Board of Education so they can use it. Then in 2016, the Vestavia Board of Education, they wanted to use the Old Berry High School. Problem, it was located in Hoover. So they made a deal with Hoover. And Hoover de-annexed that property into Jefferson County. And then Vestavia came and annexed that property into Vestavia so the Board of Education could use it. And that's exactly what happened again in 2015 in Helena with the girls' softball field. Helena de-annexed it into Shelby County. And then that was adjacent to Pelham. And so Pelham then annexed it into Pelham, and the Pelham Board of Education used it. But in 2018, they came in and said, despite the statutes, despite what we've done before, if you won't give us a deal, then we'll just wait 3 years and we'll just run over you. Okay? And that's a problem. And I think the problem gets solved when you look at section 16:11:9. Now, there's a couple of sections that deal with the power of a city board of education. One is 16:13:199, and that's when you establish a board of education. And that says they will have the power and control of the schools within the city, okay? And then here, when we look at 16:11:9, it says the City Board of Education, and that's the Pelham Board of Education, vested with the powers necessary and proper for the administration and management of the free public schools within such city. That'd be Pelham, not Helena. But then it says, and the adjacent territory to the city, to Pelham, which has been annexed. Well, the 52 acres here has not been annexed. And it makes perfect sense because if the territory is inside Pelham and they do something, the Pelham Board of Education does something that the people don't like, they get to vote for that. But if it's in Helena and it has been annexed into Pelham, we don't have any recourse. We can't vote. We can't change the taxes. They're just affecting government power on us, and they're not accountable to the people that feel the effects of that power. And so it's our view that if it's annexed, then they would be fine. But they couldn't strike a deal. They just ran over us. And so what do they say?
Mr. Haddon, let me
Yes, Your Honor.
pause you right here. So I'm familiar with the circumstances you're talking about, the Birmingham area, annexation, de-annexation, and that may be a cleaner, more, cleaner way of doing it without so much friction as we have here today. But I guess the question is, do they have to do it that way, right? I mean, is it required under the law that they do it that way, annexation, de-annexation? And so I'm looking at the statute, and I'm just wondering, I mean, the clause of the free public schools within such city in adjacent territory to the city, which has been annexed as a part of the school district, doesn't that modify schools only? Is that the most natural reading of the statute?
No, Your Honor. I think if you look at the treatise you've cited many times, Reading Law by Justice Scalia and Brian Garner, in Canon 18, it talks about the last antecedent. And in that canon, what it says is that a clause, and in this case it would be the which has been annexed clause, is deemed to modify the closest antecedent to it, the last antecedent to it, that'd be adjacent territory to the city. The limitation on that is as long as it makes sense in the reading of the passage, okay? And so here, when it says the free public schools within the city of Pelham, okay, and adjacent territory, well, that would, of course, be not within the city, because this adjacent territory has to have meaning, so it has to be outside the city, and adjacent territory to the city, which has been annexed. And if you look at the city annexation statutes, like 114221, I believe, that allows a city to annex contiguous or adjacent property. And so that makes perfect sense with the power of annexation of a city and with respect to the last antecedent canon. All right, so now they make an argument.
I'm sorry, I'll
Yes, Your
follow
Honor.
up down here on the end with Justice Mitchell as well. But you would agree that this statute is not designed for the specific circumstance we're in. For instance, the legislature with jurisdiction for municipalities for police officers. I know a number of years ago people got upset with policemen in small towns going outside of their city limits to write tickets. So the legislature specifically restricted their territorial jurisdictional limits, but this statute isn't specifically written for this circumstance. Would you agree with that?
No, Your Honor, I think it is specifically written, because if you're looking at where do they have power, that's our argument. They don't have power.
Okay, but you would agree that school boards daily exercise power outside of their territorial limits. And I'll throw out this morning, driving in about a block from here, I saw school buses that had Franklin County schools on it, Colbert County. There's something going on. There's Shelby County had a school bus. And
Your
so
Honor,
the Board of Education still has jurisdiction of those teachers and students in that school bus.
Your Honor, I think that's the difference between a governmental function that's exercising governmental power and consent. Let's take an example that if the Pelham High School football team wanted to go to Dothan and play a ball game at Rip Pugh Stadium, they get to go. And they are employees of the Pelham School Board, and they've got to do what the Pelham School Board says. That's more of a private entity, because the governmental entity that controls Rip Pugh Stadium is the Dothan Board of Education. And they are invited there, and they can do things by consent. They can come and play at Rip Pugh Stadium by the consent of
The school board would still have authority and jurisdiction to expel a student that gets on a fight on the school bus, or if the driver, runs a red light and causes a wreck, they could discipline him, engage in the lawsuit. So
just like a private employer could, Your Honor. But what they can't do is the Pelham High School team can't go to Rip Pugh Stadium and demand and say, I know, Dothan, you're going to play Enterprise, but no, today you're going to play us. Because at that point, the Dothan School Board says, excuse me, but we run the Rip Pugh Stadium. Our taxpayers voted for us, and they paid for this stadium, and so we're going to run it.
the statute doesn't seem to make such a distinction, one that you're attempting to rely on, it seems like.
Well, Your Honor, I think the statute says you have the powers where? You have the powers for proper administration, management of the free public schools, where? Within the city and the adjacent territory that has been annexed. It's true that they send teachers to go for education outside of the city limits. And they send basketball teams to go play basketball games outside the city limits. However, the motel that takes the teacher, that's by consent. They have to be invited to come play in Helena or in Dothan, because if they're not invited, they can't exercise power inside Pelham and force Dothan to accept their team there.
I think we may just have to move on that point, but I would still submit to you, there's a fight on the school bus. The school board owns that bus, regardless whether it's in Alabama or another state or wherever, still have the power necessary, broadly speaking.
It's one thing, Your Honor, to exercise that power over your employees and the students in your care. It's another thing to enforce it on citizens who don't vote for you in an area that's not within the city of Pelham. And so we would cite you to a case. Chambers can't, go ahead.
There's cities, I live in a city that has a city school system, and there's a county school system. And I have to pay taxes. Part of my property taxes goes to the county school system, over which I don't vote on their school boards. I'm not sure I'm following that. The one other thing, and I'll let you go with this, that I specifically wanted to discuss with you. Would you agree, though, that unlike municipalities, a school board in Alabama is exercising a purely state function? That under our Constitution, the education of children in this case, the public education, is purely a function of the state of Alabama. It simply delegates the school boards, and so therefore, necessarily the jurisdictional boundaries aren't quite the same as, for instance, a municipality just attempting a hostile takeover of land in another municipality.
And Your Honor, I don't agree with that question. That's their argument, and here's why.
Don't agree that the education, public education, is a state function?
I do agree with that.
That's specific.
However, as with many state corporations, they are limited to the powers that they are expressly given, and those necessarily instant thereto. On page 18 of our opening brief, we cite Chambers County v. Slaughter, where this court said a board of education is limited to the express powers it is given, plus anything necessarily instant thereto. Okay, and so there is no power here to go outside the city and exercise governmental force. And what they're doing in Helena is not just taking care of their own employees and not acting like a private employer would. They're trying to act like a government. They're going to say, we're exempt from your taxes, we're exempt from your zoning regulations. And so we think that just doesn't work. And I would say with respect to the governmental function exemption, their other big argument, we would say that fails for three reasons. No statutory authority, which we've just been over, no limiting principle, and chaos. All right? If the limiting principle of a government is that the voters in the area affected by the exercise of governmental power can vote and pay taxes and do something about that governmental action, all right, then that doesn't apply in Helena because we can't vote in the Pelham city elections. So we don't pay taxes there.
Mr.
But they would say,
your time has expired.
thank you, Your Honor.
And for the sake of the audience, he has reserved 5 minutes for his closing arguments. Mr. Johnson?
Thanks to you all for the privilege of being before you today and considering these important issues. The overall issue, the overarching issue here, in my view, is the authority of a Board of Education to acquire and develop real property to serve and support its educational mission, which, as Justice Mendham has properly indicated, is a state function. It is delegated to some extent on a local level, but the cases are legion and consistent to the effect that local school boards are indeed agencies of the state of Alabama. It puts them in a significantly different posture than a municipality. One of the problems that has infected the city of Helena's position from the beginning is a misconception of the nature of the opposing entities, for lack of a better way of describing it. Helena would like to frame the issue in terms of the city of Helena versus the city of Pelham. Although the city of Pelham the city council appoints school board members, it has no other control over the Pelham School Board. It is an agency of the state of Alabama that answers to the state educational authority, state superintendent, department, and boards of education. And indeed, in this instance, and significantly, the record is clear and undisputed that this project, as all state educational projects of this type, was submitted to the State Department of Construction Management for initial permission, for design review, and for inspection and ultimate approval. So every aspect of the project was under constant, close scrutiny of state authorities. That puts this circumstance, I think, in an entirely different light. It's important for the court, I think, to keep this in mind. This is not a Pelham versus Helena issue. This is a case in which the city of Helena is attempting to dictate to a state agency whether it can acquire and develop property. Now, the authority of the Pelham Board of Education to undertake this mission, and again, it's designed to support the existing educational endeavor of the school system. It's not designed to expand the Pelham Board of Education's jurisdictional reach in the sense that it's reaching into Pelham to Helena to attempt to take on or take in Helena residents. This is a practice field, a parking facility that lies immediately south of the existing Pelham High School campus. Some of you may be familiar with the layout. Pelham High School sits atop a rather large hill. It's somewhat landlocked. This was an opportunity that the Pelham Board felt it could not pass up, property into foreclosure. And so
Okay, so this is not, we're not dealing with a public taking. You actually paid for this property.
paid well north of $400,000 for the property, Your Honor. Yes,
So
indeed.
it's not a public taking.
Not a taking. And again, Justice Wise, your question raises this concern in my mind. From the inception, Helena has viewed this matter, I think, in terms of its, inaccurately so, a right of ownership of the property. It has no, whatever its sovereign interests are, and it uses the term our sovereign interests throughout its briefs and has at every level, it's not the same as ownership, but they treat their presumed sovereignty as though it implies and carries with it the right to own the property or to control who does own the property. There's no way to read the state code to invest a municipal corporation with the right to control who can acquire property.
So who pays tax on the property?
No one will pay tax on the property.
Does that then diminish the city of Helena's tax base?
Pardon me?
Does it diminish then the city of Helena's tax base when you sell property to an exempt entity?
It would diminish to some extent, yes.
Can we take any of that into consideration?
No, in the sense, no, Justice Sellers, in the sense that you have governmental operations of all kinds acquiring property within municipal corporations, and that is the natural and necessary effect of that acquisition. That, for most part, it confers tax-exempt status, of course, on the governmental entity. But this property is fallow. This property was undeveloped. It was at one time the subject of a proposed development that never has materialized. For most of its history, it has been undeveloped, fallow property. The city of the Pelham School Board, rather, has acquired it for the limited purpose of providing support facilities to its existing high school. The high school itself, of course, is within the city limits of Pelham. You're talking about 10 acres or so of a 52-acre tract. The Pelham Board of Education has no plans to develop the remainder of that tract at this time. And so it's a very limited sort of proposition.
So Johnson, could I interrupt you right quick?
Of course.
Just take you in a little bit different direction. Fully understand your comments about the need for the land and the uses to which it will be made, and the state essence of it being a state action. But could you tell me what that section means?
Yes, I think it means this. I think the section that they're relying on, I think it refers to the operational reach of the district. In other words, the students it serves. The student population, the student service base here has not changed one iota since the acquisition of this property. We are not taking on additional administrative duties or obligations or rights, if you want to look at it that way. We're simply building a facility that serves an existing student population base. And I think that's the sense in which we understand it. It's not a geographic limitation, it's an administrative limitation. but it's defined in terms of the population base that is served by the district, not an
If we were to say that, and I don't suppose there's anything that prevents the Pelham Board of Education from buying that land, but I'm having problems with that statute there. It seems to have a geographic component to it, does it not? The City Board of Education, let's substitute some words. The Pelham Board of Education is hereby vested with all the powers necessary or proper for the administration and management of the free public schools within Pelham and adjacent territory to the city which has been annexed as part of the school district, which includes the city having a City Board of Education. I want to try to, you can buy that property, but do you have any, is that a limitation on Pelham? And if it's not, can you tell me why?
I don't think it is a limitation, because, and I think your questions about buying the property are entirely appropriate. If you can buy a property but you can't use it, you really cannot buy it. The right to use property, in my mind, and I believe the cases support this heavily, the right to buy property implies the paramount right to use the property. If you can't use it, you really can't buy it. It would be a complete waste of money.
Would you say that this is a latently ambiguous statute or a patently ambiguous statute? Is it an ambiguous statute that is requiring construction?
Well, there is a way to read ambiguity. Yes, there is a way it can be viewed perhaps in a different light. But I think the key here is to take into consideration the statutes, the other statutes that speak specifically to the school board's authority to acquire property. And those are set forth on page 40 of our brief. Those include 1611.9.1, to take such actions as the board deems necessary and appropriate for the proper management of the public schools. This is such an action. This board felt it was appropriate to acquire this property, to protect its right to expand its athletic facilities and its service facilities, not to move the school itself, but simply to better serve the functions of the school. To exercise 1611.12, to exercise full and exclusive rights to purchase real estate for the use of the schools. That's exactly what happened here. They purchased real estate to be used in support of the service and mission of the school itself. A clear, direct grant of authority.
Mr. Johnson, under your reading of the statute, would there be any geographic limitation on the Pelham Board of Education be able to go and purchase property? Could it go and purchase property in Wilsonville or Columbiana or?
I think a rule of reason at some point would enter into the conversation were that to be, were there to be an extreme example of acquiring property that could have no meaningful use for the benefit of the student who reside in Pelham. And again, it's where the students reside that is the key here, I think, to the analysis. So if no Pelham resident could reasonably benefit from the acquisition of property in Wilsonville or some far-flung location, I think a case could be made that this might exceed the discretionary authority of the board. Call the court's attention to your long-standing precedent in the Phillips case, the Blount County Phillips case, Blount County Phillips and Mullins Board of Education, cited page 41 of our brief, which expressly holds that decisions regarding the acquisition and location of school facilities is legislative in nature, administrative in nature, and discretionary in character, and it cannot be reviewed or challenged except in the case of fraud or corruption. No one's contending that this purchase was the product of fraud or corrupt motives at all, nor could it be. And so I think falling back on that precedent, we were well within the scope of our discretionary authority in making this purchase.
Can I play devil's advocate here, though? I'm sorry.
Please.
Was your,
Go ahead.
was your question answered? And so this is a 52-acre tract? Is that correct?
Yes, Your
And
Honor.
you said you're using 10 acres right now? There's no plans to go beyond that? There are no plans right now. You know, for instance, 20, 30 years from now, what if the school board decides to sell this property and a neighborhood now is put in these 42 acres, there are 32 acres that are left over? Where do those kids go to school? Do they go to school in Helena or do they go to school in Pelham?
They would go to school in Helena. They would be within the city, they would go to school. Keep in mind, Helena does not have its own Board of Education. It is served by the Shelby County Board of Education. So they would go to the school for which they are zoned within the Shelby County system. And I would point this out too, in reference to these matters. The governmental function that we're talking about is limited to, in this case, school-related functions. We couldn't put, a casino or a Chuck E. Cheese or something on the property and go into business. That would be subject to Helena's jurisdiction, its zoning.
So why,
It doesn't expand their footprint. This does not expand Pelham's footprint. The
No,
purchase of this
no, Your
property.
Honor, it does not. It's just an acquisition of property that is necessary in order to provide the additional support to the existing school facility. It's not changed the school district per se.
so what restricts the use of the property? Is it zoning by Helena, or is it the statute that says boards of education can only do things related to education? I mean, you couldn't build a Chuck E. Cheese, you said, but is that because, well, there's zoning rules we have to deal with because the property's in Helena, or is it because the statute about use and ancillary uses and all that? What restricts your use of the property?
Statutes, and some of them I've just read, of course, that tie the authority of the school board to acquire property to school-related purposes and uses. But more broadly, the case law, I think, supports the notion that if a public entity gets involved in what the case is called proprietary activities, that subjects them to a different analysis. Whether it goes so far as to say they cannot acquire it, I'm not prepared to say universally or globally. It would depend, of course, on the circumstances. But to the extent it is a proprietary enterprise, I think at the very least, the property would be subject to Helena's land use and zoning regulations. This,
Even though you've purchased the property, the Board of Education purchased the property, but you still, under your argument, you're still going to be subject to Helena's zoning ordinances, land use regulations?
with respect to proprietary, non-governmental uses, yes, Your Honor. I think that is a fair reading of the case law, if not the statute.
Mr. Johnson, could I ask a quick question? Because of your light is yellow, you may not have time to give me a full answer, but just to get a sense of, from an analytical approach, would you think that we would look at this statute, 1611-9, and other statutes that you've mentioned as sort of a universe of the law in this area, and it would tell us by looking at all four, this is the scheme? Or would you take a different approach and say, well, all of these other things out here suggest this. This is kind of an outlier. This is ambiguous, so we might perhaps use these other statutes to sort of garner the intent of what they were trying.
I would be inclined, Your Honor, to take them as a whole, give them a sensible, reconcile as you would do in almost any context, attempt to reconcile all of the relevant statutory authority, but do so in light of and with respect to the precedents that this court has established. We've cited most of them, if not all of them, in our brief. And there are, as you perhaps have noticed, numerous Attorney General's opinions that apply a very liberal point of view with regard to what I would call extraterritorial acquisition and use of property, not only on behalf of school boards, the Alvis and Lauderdale cases come to mind, but with regard to other municipal undertakings. And so taking all of that authority together, I think the fair reading and taking into account practical circumstances here as well, the physical and geographical, topographical rather, circumstance that the school finds itself in, and say, this is reasonable, this is not fraudulent, it's not corrupt, it's not done for an improper purpose, it is done to support the activities of the school. So we can very comfortably say it fits within the larger compendium of education statutes that have a bearing on the right of the school system to manage its property and to acquire it.
I appreciate that, and perhaps Mr. Haddon would address that same question too. Thank you.
Again, I've mentioned the standing issue. I think that's important for the court to keep in mind. Mentioned the Blount County decisions, but also I'd ask you to consider just the practical consequences of your decision here. Land, as they say, we're not making any more of it. Schools have a way of growing, like churches and other institutions. This school system is proud of what it's done at Pelham High School, but it doesn't have unlimited space. This is an opportunity, this property was acquired as an opportunity to plan for responsibly the growth of the facility. And there's nothing, I might say, it impinges on no interest of the city in an adverse way, on nothing adverse with respect to negative impact on surrounding communities. You can't see the facility from any surrounding community. It is well buffered in every respect. So there's none of the typical zoning controversy that attaches to this particular use. It is a healthy and appropriate use of money. A lot of money has been spent here on the equitable side.
That brings up a question for me.
Please.
In what part of the construction was this case filed? I know now it's substantially complete, or it may even be complete, but was it just movement of ground when this case was filed?
Justice Wise, my recollection is that there were preliminary activities. I can't tell you exactly what there were. That triggered a conversation between General Counsel for Helena and city authorities, the Pelham School Board. That led to a discussion. The focus at that point was on the question of Helena's zoning authority. And so that led to an agreement that we would submit that question for determination in a declaratory action, Shelby County Circuit Court. The case has since morphed beyond that. I would just point out in closing, my time's up, every court that's looked at this has said, you're correct. So we proceeded, the Pelham Board, were correct and within our rights, so we proceeded under that authority in the aegis of court endorsement.
Thank you, Mr.
Thank you
Johnson.
all.
Now, as I had said earlier, the appellants reserve 5 minutes of their time for their closing.
Justice Shaw, to your question with respect to all the educational statutes being read together, I agree with that. I think in our brief, we talk about the case of ex parte Jones Manufacturing. Ex parte Jones Manufacturing, it says when you have a bunch of code sections related in a single statute, like the education code, you try to read them in paramateria together, to work together and try to avoid a conflict. But their reading creates that conflict. In section 1611.9 that we had put up there before, it says within the city or adjacent territory that's been annexed. But for example, section 9.1 that they cite has no geographic limit. It just says management and administration of the schools that are necessary and proper. But the next clause that they don't quote in their brief says, provided, however, it won't conflict with any other law. Well, 9.1, if judicially interpreted so you can go outside your city, would conflict with section 9 that says you have to be within your city. So I think when we look at the state statutes, I think we have to have some type of limiting principle. We didn't hear one here, something about reason. I think we look at the state statutes for the limiting principle. And let's look to how they interpreted their own statute. In 1613-199, it says the control of schools or schools of the school or schools of the territory within the municipality shall be vested in a city board of education within the municipality. And then we look at their resolution that they drafted, that they passed. It says the Board of Education shall be vested with all powers necessary and proper for the control, administration, management of the public schools within the city of Pelham. Okay, not outside. And so
Mr. Haddon, was this resolution the initiation of the City Board of Education?
it was, Your Honor. And so we would suggest that their interpretation of the state statutes governing the state law should control here. That's actually a limiting principle. And let's say, what happens if you don't have it? Or excuse me, before they get that, they mentioned the Attorney General's opinion. And I'd like to talk about Attorney General Opinion 2002-2.
Mr. Haddon, very quickly going back to this point, I know we're running out of time.
Okay.
But my understanding, reading through the briefs and the record, that your client has never said that the Board of Education does not have the authority to purchase property outside. But then it seems like you're arguing that they have no power outside of the physical boundaries. So therefore, if that's true, it seems like the contract to purchase this property outside of their physical boundaries would be an illegal contract if they have no.
Oh, Your Honor, I think what we said in our brief is what this court said in the Fort Payne case, that there's a difference between exercising sovereignty and exercising ownership. A private person can own property, but only a government can exercise sovereignty and tell people what to do on that property. And that's what our argument is, that the administration and management of that property, that's what has to stay within the city of Pelham, as is per the resolution they wrote to establish their Board of Education.
Then the contract would be illegal.
No, Your Honor, it surely would not.
All they want to do is, for instance, and there may be other stuff going on the property, but pave a parking lot, or let's just say it maintains this as a flat dirt area when the school board purchases it. They're still going and use it nothing but for overflow parking. They would still be exercising their sovereignty as far as the education of students over that piece of property.
Your Honor, if they submitted to the zoning zoning regulations of Helena, if they paid taxes on it, they'd be acting in a proprietary function, not in a governmental one. But here they want to act in a governmental one, and that's what we say is limited. State government.
If it's a parking lot for students, that would be for the benefit of educating students. They would have. Wouldn't you concede that would be exempt from any sort of zoning or regulations?
No, Your Honor, and here's why. If you look at there are two. The reason their lack of a limiting principle is dangerous here is that this court has never extended the governmental function exemption to the place where you have one city dealing with one city's Board of Education dealing with another city where the voters can't vote or pay taxes. In the Alves case they cite, it's a city Board of Education going to a city where the affected people in the public can actually vote on that. If they don't like it, they can vote for the city commission and get rid of the.
Keep in the back of our mind what we discussed earlier, that a Board of Education is simply acting on behalf of the state of Alabama. So
correct. A state Board of Education, limited by state statutes, is all they can do. Is what the state statutes say. That's Chambers County v. Slaughter on page 18 of our brief. If they don't have the express authority, they can't do it. But now, it has real consequences, Justice Mendel.
I'll get in trouble with the chief in a second. I don't get to follow up.
Finish your answer.
Enjoyed our parlay. It's always good. You're a great lawyer. Thank you.
Well, what's dangerous about this, Your Honor, is the chaos part. When they come over, as my colleague said, into Helena, and they use it for educational purposes, that takes it off the tax rolls. But still, we have to provide police and fire protection. At C-815 and 816 of the record, that happened. An excavator got vandalized. We had to send a policeman out there to take care of it. There's a dispute. Which police department controls? Well, since it's in Helena, it was Helena's department. So, under their reading, We don't get the taxes, but we have to provide the services. And if that's going to be the law, which has never been adopted by this court ever, to say one city can go into another city and do this, if that's the law and they're not limited by that statute, then every city board of education in this state will say, yeah, I'd rather take somebody else's property off the tax rolls. Yeah, I'd rather have the police and somebody else have to pay for this. That way we make money. I'm all for making money. Well, if you're going to give that financial incentive to every city board of education in the state, that will be chaos. It's never happened before. It shouldn't happen now because they're limited by the statutes. They themselves wrote the resolution and admitted they were limited.
Mr. Haddon, thank you.
Your Honor.
Well, we thank the counsel from both sides for good arguments. And with that, we will take the case under consideration and we stand adjourned.
All rise. Court is in recess.